Ruggs was driving under the influence, going 127 miles an hour, killing 23-year-old Tina Tinter and her dog.
Henry Ruggs plans to plead guilty to felony counts of DUI resulting in death that will lead him to serving 3 to 10 years in prison.
Welcome to Unshut Cases. On today's episode, we have with us an incredible attorney out of Cincinnati, Ohio, Shane the Shark Herzner of Herzner Law. Shane, thank you so much for joining us today on Unshut Cases.
Thank you so much for having me. I look forward to the discussion.
Me too. And this is an interesting case we're covering today. It is the Henry Ruggs fatal car crash case from 2021, which occurred just outside Las Vegas, Nevada. Shane, you are a DUI, domestic violence, drug and narcotics lawyer in Ohio. Just to kind of give our audience a brief overview about you, you co-authored an Amazon best-selling legal book called A Cup of Coffee with 10 of the best DUI attorneys, certified in the training of the National Highway Traffic Administration and the standardized field sobriety testing. Although your main practice is DUI and OVI offenses, you also do traffic and criminal offenses as well. So obviously this Henry Ruggs case is really kind of right up your alley in terms of your expertise, and just we do appreciate your insight here today, and excited to kind of walk through this case with you.
Yeah, absolutely. I look forward, like I said, to kind of discuss. And I think it's a really interesting case, especially with all the different background factors and with the media being involved.
Yeah, for sure. And just to kind of give our audience an overview here, Henry Ruggs is a former NFL wide receiver. He played for the Las Vegas Raiders, previously played football for the Alabama Crimson Tide before being drafted by the Raiders in the first round of the 2020 NFL draft. So this incident actually happened just a year after his draft class. In November of 2021, he rear-ended another car at high speed, which caused the fatality of 23-year-old Tina Tinter and her dog. They both burned to death as a result of the crash. Was horrific. Before the incident, Ruggs was seen drinking with his girlfriend on the Las Vegas Strip, left after midnight in his Corvette. Digital evidence of this crash showed him driving at 156 miles per hour before attempting to brake as he rapidly approached the car, lost control and hit her at 127 miles an hour. Police reports showed that Ruggs had refused to take a field sobriety test. His blood test taken 2 hours following the crash revealed a blood alcohol content of 0.161%, more than twice the legal limit in Nevada. Ruggs and his girlfriend were then treated for non-life-threatening injuries. This obviously spun into litigation. Ruggs was arrested upon release from the hospital, charged with driving under the influence, resulting in death and reckless driving. He appeared in court the next day, took bail at $150,000. Ruggs' attorney argued that he was unable to submit a field sobriety test because of his injuries sustained in the accident, claimed that the blood test should not be admissible as evidence since the police did not have probable cause to obtain a blood test. A justice of the peace rejected those arguments and ruled the blood test admissible as evidence in this case. Then in May of 2023, to kind of fast forward a little bit, Ruggs took a plea agreement and pleaded guilty to 1 count of felony DUI resulting in death and 1 count of misdemeanor vehicular manslaughter.
I have no excuse and pray that accepting responsibility in my guilty plea can allow me to begin the healing process.
We hope that Henry's truly heartfelt acceptance of responsibility brings some closure to Miss Tinter's loved ones.
Prosecutors said they reached a plea deal due to concerns the blood drawn would be thrown out, and with it, the only evidence to support the felony DUI charge. They were not willing to chance Ruggs only facing charges of reckless driving, which could have resulted in probation. And then he was sentenced on August 9th, 2023 to spend between 3 and 10 years at High Desert State Prison in Nevada. So again, there's a lot of sort of angles and just detail to this case that are kind of interesting to dive into. Obviously, it's tragic. It's horrible what happened here. Shane, in a high profile case like this, with a known person, a celebrity, famous athlete, does media coverage play a factor in how the proceedings go? And was that a factor here for Henry Ruggs?
I think media coverage absolutely does play a part into it. And the reason being is it's hard to get a jury that hasn't heard about a case like this when it hits the national news and when you have a high profile athlete such as Henry Ruggs III involved in this accident. So it's not uncommon to have cases like this where you have to file motions to try to change venues so that you can get an untainted jury. But again, when it's a national case like this, it's still really, really difficult. As far as his notoriety becoming an issue, I think it kind of could cut both ways. Sometimes celebrity, if they're well known and they're liked, it can be in their favor. Or if it's somebody where the public doesn't know, then it could work to a disadvantage because they just assume that the person is impaired based off the media coverage.
Yeah, it's interesting. Obviously it's a totally different case and incident from the O.J. Simpson case, but you're just reminding me obviously of another famous high-profile football player case who, was very public trial early 90s. And to your point about the jury and just sort of people being unable to kind of get information, there's like a media frenzy, right? So you're like, how do you sort of isolate those people that are going to be in the jury deciding on this case so that they're not exposed to the narrative in the media and kind of all of those elements of it? In this instance, police reports had stated that Ruggs had refused a field sobriety test. So he was instead given a blood test 2 hours later. How common is this? Is it a common occurrence? How was he able to refuse that field test?
Those field tests are actually optional. No one has to do them. And it's my understanding is that he did sustain non-life-threatening injuries, but still some pretty serious injuries as a result of the accident. I think even at his arraignment, he had a neck brace and he was put in a wheelchair and he was wheeled into the arraignment. So it's incredibly difficult to do the field sobriety test anyway, but to do them after being involved in a car accident when you were traveling 126 miles an hour upon impact is even more difficult. And if they're optional, I generally tell you don't do them anyway. And in this particular case, that's probably the situation, is he knew he didn't have to do them. As far as the blood test a couple hours after, on accident cases, they do allow you some time to get the blood results because the focus is on clearing the scene, making sure everybody's okay and taking care of the injuries first before they actually request and do the blood exam.
Okay. With his blood alcohol level nearly twice the legal limit to drive in Nevada, safe to say it was likely much higher 2 hours before, right? During the incident. When used as evidence, is that time lapse taken into account? Do they need to go off only the given blood alcohol content at the time that he was tested, or how does that kind of come into play with that gap in time?
Sure. As a defense attorney, you always have the ability to raise some questions concerning what the BAC was at the time of operation, because that's what they have to show, is that the person was impaired or over the legal limit at the time of operation. Statute allows you to prove that it was over by doing the blood draw, even the 2 hours afterwards. They can still make their per se case. As far as where his BAC was at the time of operation, it's really hard to tell because everybody metabolizes a little bit different, and there's lots of scientific and mathematics behind calculating a person's breath test if you don't actually have it, or BAC, I should say, in this particular case. So whether or not he was going up or going down, it would be tough to tell unless you had additional information, such as when he had stopped drinking, what he had to drink, those type of things. Because most of the time, personal peak and then slowly the alcohol, gets out of your system.
Okay. Why do you think prosecutors here were worried that the blood test could be thrown out as evidence?
Because it's such a technical thing to get this blood draw, to make sure that it's properly handled, properly tested by the right people. There's lots of room for error. And I know they may have won at the motion stage to allow the blood test in, but if Mr. Ruggs was ultimately convicted at trial and the blood test was allowed in, there's always appeals. And that means that the family is dealing with this the entire time. It means that Henry Ruggs is also dealing with it through the appeal process. So I think the state didn't want to take a chance. They were getting the higher level charge, which is the DUI resulting in death. So I think that was a fair compromise, and these type of plea deals are pretty common.
Okay. What's the difference between the charge of DUI resulting in death and vehicular manslaughter. Can you kind of just give us an overview of how those are different and kind of how they converged here just in this specific case?
Sure. You usually, a good prosecutor, when they go through the indictment process, will make sure that they cover every single charge that could come out of an accident. Mm-hmm. So in this particular case, they obviously do the DUI resulting in death, DUI resulting in bodily harm. I think they had 2 counts of reckless driving resulting in death or bodily harm. And then there was also possession of a firearm while intoxicated. So they're going to charge them with everything they think that they can prove with the facts that are presented to them. And in this case, it was with the felony charge, which is the DUI resulting in a death.
Right.
And if they were, for some reason, not able to prove the impairment part, which is required for the DUI resulting in death, that's why they have the reckless driving resulting in death or serious physical harm, which is a misdemeanor.
Okay.
So you obviously, anytime you have a misdemeanor, there's a chance that the person never serves a day in prison. Whereas with the felony DUI resulting in death, there's, my understanding, mandatory prison time that results with the conviction of that charge. So this was the prosecutor's way of guaranteeing that they were able to get prison time.
It's interesting. So here's a question for me about that. So hypothetically speaking, or not hypothetically speaking, he was clocked at driving 156 miles an hour. Then when he would brake and hit the crash, it was 127 miles an hour. Even if he was sober in that instance, is that still that's vehicular? That's still a misdemeanor?
Yes.
Okay. Yeah, that's it's interesting because you would think that separately, it's like you're driving at such a high speed.
And it could, again, depending on the factors involved, like here, I think they had indicated that, like you had said, the black box in the car indicated 156 and that there was no braking. So, or excuse me, there was braking right before and it was a 127. Right. So in this particular case, depending on what the information found, they could still charge him with a felony for being reckless, but it could also be conviction for a misdemeanor. So that's the reason why they charged him under both of those code sections on there, because you'll see there were 2 charges of the reckless driving resulting in bodily, and I'm assuming that one of them was the felony charge and one of them was the misdemeanor. But certain felonies carry the presumption of probation, that you're likely to get probation versus prison time or jail time. So that's the reason why you're exactly right. Somebody driving that reckless, can it be a felony charge? Yes, it can be a felony charge. You know what the facts and factors are in the particular case. There can be some arguments made, though, that he attempted to try to diffuse the situation by slowing down, although it was still 126 miles an hour, 27 miles an hour. And again, that's something that would have been argued out in trial.
Yeah. And in terms of the sentencing after trial here, 3 to 10 years, is that a fair sentence? And how, I guess, you're in Ohio, how does that differ state to state, Nevada versus Ohio? What does that look like in terms of, this sort of the precedent that's set in these kinds of cases?
Well, it's an indefinite term. And so that means he can get out in the 3 years. I believe he's eligible for parole, and I think it was August of 2026 is when he's first eligible for parole on that time period. And certain, at least here in Ohio, certain charges, felony charges, if they're felony 1s or felony 2s, they're subject to these indefinite sentences, which in Ohio, it's known as Reagan-Tokes law. Mm-hmm. So if you were to be sentenced to 4 years for a particular charge, Reagan-Tokes adds up to 2 more years to it. So it's half of the original stated prison term. So it would be a sentence from anywhere from 4 to 6 years. So I'm assuming that Nevada must have something similar where it's an indefinite period, depending on what he's doing, how he's doing while he's in prison. Is he causing any type of trouble, those type of things. And then the parole board ultimately makes the decision when he gets out.
Okay. And obviously this was a criminal case, but you also here have a wrongful death, I would say. I assume, can you speak to, was there a civil case here? And can you kind of tell us a little bit about how that would have split here from criminal to civil?
Sure. And I am not aware of any civil case right now pending, but I'm sure there will be one coming. I mean, this was a death involved here.
Right.
And I'm sure that Henry Ruggs still has some money from his contract with the NFL and different endorsements that he may have had. So I'm sure that there is a wrongful death suit. If not already initiated, it will be here very, very quickly before the statute of limitations for such a charge. Now, it's always good to get the criminal case when it comes to civil filings, criminal case done out of the way first, kind of like in the OJ trial. The reason being is a lot of the evidence gets to come out and if it's a criminal trial, defendant does not have to testify. You have your Fifth Amendment right. At a civil trial, you cannot claim that right. So if you have a criminal charge pending and a civil charge pending, you're not going to be able to get the defendant to testify even in the civil proceeding because he can't incriminate himself. So you generally will wait until the criminal proceeding is finished and over with before you file a civil suit. In this particular case, my guess is that since he had pled guilty to the charge and there was a plea bargain, there probably won't be. It'll be worked out between the attorneys. In this case, if he had any insurance through the car and through his attorneys to work something out, where I'm sure it wouldn't be a trial in this particular case since there was a guilty plea.
Okay. Well, again, Shane, thank you so much today for joining us here on Unshut Cases on this Henry Ruggs case. Can you tell our audience where they can find you?
Sure. You can always find me at my website, which is herznerlaw.com. My last name is spelled Herzner. So herznerlaw.com. Check me out. I also have Instagram under shanetheshark.com. And I'm on TikTok. So you can look for me at Attorney Shane the Shark there as well.
Awesome. Well, again, Shane, thank you so much for being here with us today on Unshut Cases, and we hope to have you back soon.
Sounds great. Thanks so much. You guys take care.
You too.